SJC-13279, Commonwealth v. Nyasani Watt.
Great, okay. Attorney Doherty.
Good morning. May it please the court. Not long after this court affirmed Mr. Watt's convictions in June of 2020, Nyasani Watt filed a motion for a new trial based on corroboration that had been accumulated that showed that his trial counsel had slept during critical stages or critical portions of his trial. A trial is presumptively unfair and presumptively.
Can I ask you though, before you get, how do you know those are critical stages or they were important parts of the witness testimony? It's not really clear that we can pinpoint exactly what happened in the record, is it?
Well, from the affiants that testified, a critical stage of the trial has been identified certainly as when evidence is taken at trial. Mm-hmm. And the affiants testified that trial counsel, they noticed trial counsel asleep during, or dozing or nodding off during particular witnesses. Some of the affiants are able to identify specific witnesses. Some of the affiants don't just say it happened at a particular, they observed it, but aren't able to identify a particular time.
Anytime evidence is being taken, it's a critical stage?
The presentation
any cases say that?
The cases, to be fair, chronic does not define what a critical stage is, but cases define it in a couple of ways. Presentation of evidence against the defendant, or some of the cases say that, but presentation of evidence at all, some of the cases. Also,
can you identify which cases say presentation of evidence against the defendant? Or
I believe that Brewer versus Williams, Green versus Arnn, which is a Sixth Circuit case, says of course presentation of evidence is a critical stage.
Well, let me ask you, when you review transcripts as an appellate lawyer, and you've got 5 pages of the Commonwealth's fingerprint expert talking about ACE V, right, and you're reading that. If the lawyer was nodding off when he went from A to E in the ACE V, is that a critical stage?
Absolutely, and that's why, I mean,
I get when the informant's testifying.
Right.
I get when the rape victim's testifying. But, like when he's talking about how we look at the same routine information. So you're basically saying anytime a witness is testifying, it's structural error.
Yes, according to chronic, it's a critical stage of the trial.
Well, chronic doesn't say that's a critical stage. Chronic talks about it. A critical, if you're asleep during a critical stage, that's a problem.
Critical, in fact, that's correct. Chronic does not provide specificity as to what a critical stage is. But a number of Supreme Court cases talk about when the defendant's interests are at issue, when there is, again, when evidence is being presented against them. I mean, sort of backing up from this, so getting back to your question, Justice Gaziano, looking through the transcript where it's a sleeping lawyer and not a temporary absence, which are some of the cases discussed that, and that's much easier to determine what happened.
Yeah, because I'm with you as far as if it's a critical stage, then we don't get to prejudice. But if it's not a critical stage, then we get to prejudice. There's a divide that makes sense to me, and I'm just trying to figure out what your rule is, how we make that distinction between critical and non-critical.
Well, Maine versus Moulton, which is another Supreme Court, it can be construed to say that the entire trial is that. And in fact, when I was thinking about, because
Just if it's the entire trial under Maine, as you suggest, then why would chronic say critical? Critical mean if it's the entire trial?
Well, I think that the definition that I like is one that comes from Tippins, where they talk about the interests of the defendant are at stake. And so in this, based on the affiant's record or their attestations, there are a number of individuals that where it would be evidence that was against the defendant. Mr. Watt identifies the fellow who lives on Rosetta Street, which would be James Costin, which that was, very inculpatory testimony. Kayvon Martin, Kayvon.
By the way, did Costin testify against both defendants? Because we have 3 defense lawyers in this case.
We do.
Two for the co-defendant, one for Mr. Davis for the plaintiff. I mean, for your client.
Yes.
And their defenses are aligned. When Mr. Costin is testifying, is he talking just about your client, or is he talking about all 3? I mean, all 2 of them. Yeah.
I believe there was. I believe it was more as to my client, if I recall. But I think that there was probably some that implicated Mr. Mattis. But that's 2 things on that. One, I know the motion judge rather, indicated that the defense was aligned, and so the fact that there were other lawyers there, those lawyers were not protecting my client's. His interests.
That's fair enough, but the fact that if it were a joint defense, that if we get to prejudice, that's a factor.
It was really not a joint defense, and I would also point out that I believe it's Ragan, how it's pronounced, that was also a joint trial, and. And in fact, 2 of the lawyers who testified about Mackey, who was the lawyer who was sleeping, represented the other defendant. In addition, U.S. versus Russell, which I cited both in the reply brief and my principal brief, says that it just says that that's not allowed.
How about the fact that the judge doesn't notice ever, right? We've got nothing from the judge indicating that the counsel's asleep, right? Absolutely 0, right?
The judge didn't decide the motion in this case, which was a surprise to me.
No, I'm talking about at trial.
Yes.
At trial we have a couple of times where the prosecutor, who's now a judge, says he had to kick the chair once, but the judge is completely absent on this issue. Meaning, the judge sees the lawyer asleep, he or she's going to wake him up.
You would think, Your Honor, but we don't have anything in the transcript, to be sure. Mm-hmm. We don't have any, but we didn't have anything that came out in the evidentiary hearing, because there wasn't an evidentiary hearing, but also it wasn't heard by the trial judge. So I don't really have any answer for that.
So we're basically making our decision based upon the affidavits, the unrebutted affidavits of the 3 lawyers.
The trial judge did not weigh in on this.
Let me ask you a different question, that being waiver, which is a big issue, and that you've spent a lot of time addressing it, so I want to give you the opportunity to tell us your thoughts on that. We have here, and I'll give you my concerns, we have here the defendant told predecessor appellate counsel of the issue, wasn't raised on appeal. You raise his age, but by the time it gets to an appeal, he's 20 years old and 24 years old by the time it's argued. So even if we agree with you that the age is relevant, how isn't it not waived when the appellate attorney knows?
Well, so I'll back up a little bit.
Multi-part question, you can.
With respect to the age of the defendant at the time, the affidavit, my affidavit that recounts my conversations with prior appellate counsel, which is the evidence that we have, does not, to be fair, does not indicate when that took place. It doesn't, I mean, as I recounted in my affidavit, going through the trial, the case file record, there was no indication of that. But I think we have to assume, and I think we need to infer, and I think it's a reasonable inference, that that conversation would have taken place at the beginning of the representation. And the record shows that prior appellate counsel was appointed in December of 2013. At that time, the defendant would have been 21, still within the range of a late adolescent. And
What does that have to do with letting the council know and then the appellate counsel know?
Right, because the point I'm puzzled about is we have a defendant who tells his lawyer, hey, my lawyer was asleep, trial counsel was asleep, and then you talk about his diminished age, et cetera. But what standard do we have where we don't expect any defendant to say, other than tell the lawyer the facts and let the lawyer marshal the facts? Because I don't expect any defendant to say, well, you didn't raise that in the brief. What about my Sixth Amendment rights? What about chronic? No, who does that?
I think still that at that time, his age can be seen as an impediment, as a deficit in not pressing that issue.
What else do we have a defendant do other than tell the lawyer who's trained in the law the facts?
Well, I mean, I think that, again, that he would have pressed it more enthusiastically, more had he been an older.
I don't know if that's a realistic standard, because if the lawyer decides whatever and he's weighing what to raise and what not to raise, I guess he could have filed a Moffett brief, but I don't understand how his age has anything to do with not communicating his displeasure over this issue.
Well, I think given the response that was told to me by prior appellate counsel, that he said that this wouldn't lead to a claim of ineffective assistance of counsel, which in fact was the wrong constitutional deprivation of right in this case. Once he was given that, my client was given that information, he dropped it. And in fact, didn't bring it up again, didn't press it.
But you think if he was 30, he would have pressed it?
I think there's a more reasonable expectation that someone who was older, had more experience.
So we should generally see an increase in anxiety volume and emphasis as people age?
And legal acumen.
Right, well, yes. I think so. I think an experience and
Isn't
whatnot.
Counsel, could you go backwards for a minute, though? Because you make these arguments based on Diachenko and Miller and all these other cases that talk about the developments in adolescent brains. But where have you ever seen those developments applied to procedural aspects like waiver? I mean, the context that they come up are things like criminal responsibility and sentencing. When has that ever been applied the way you're suggesting we should apply it here?
Well, I think that I'm not asking for there to be a rule. In each case where you consider waiver or the newness requirement for 33E, it's case-specific. It looks at the circumstances. And I think that this is a circumstance that can be considered as to whether there is waiver.
So how would that look? I mean, say it was a public trial. Is there and you're looking at whether or not people were excluded during impanelment. Is there a doctrinal framework that ebbs and flows depending on the age of the defendant?
Well, and I'm going to sort of get into something, and if I don't answer your question, please let me know. But I think that it's very clear, and this court has carved out sort of exceptions for different types of structural errors. In Francis, they made a great distinction between the public trial right and other rights. This particular right, this deprivation, denial of counsel, is one that, in each case,
That was your lead argument. I think I think I agree with you that obviously if we say this was a critical, if we have a lawyer who's sleeping during a critical phase of a trial, structural error, no prejudice, you win, right?
Wonderful.
Right. But it doesn't, you're going with your strongest argument. When Justice Lowy asked you about what do we do with this issue of waiver and age? So.
Well, as I say, getting back to what Justice George's question, I think it's a circumstance that can be considered. I don't think the court looks at, I don't think they identify it as fault, but there is, in each sort of waiver case, there's sort of an underlying notion of like, were they at fault for this?
So, counsel, who was the first attorney who should have raised this issue?
Well, I suppose that the prior appellate counsel should have
And you don't bring an ineffective assistance claim against him, right?
I did not, and I expected that question would be asked today. I think that in pursuing an ineffective assistance of counsel against appellate counsel, I think it still brings us back to whether
that
there is.
relates to waiver, though. That's an important factor in waiver. And you brought up Francis, and Francis was an example where the fact that it sat around for a long time strengthened the waiver argument. And here, you know, the defendant does what he's supposed to do. He brings it to the appellate counsel, but the appellate counsel doesn't do anything because he thinks it's kind of silly. And now you're not saying he was ineffective, but now you're saying we should. It wasn't silly. I don't know what we're supposed to do with all of that.
Well, I mean, also analyzed as a claim of ineffective assistance of counsel of prior appellate counsel tends to be sort of outcome determinative in a way that is difficult for this case. And I would also suggest.
I don't understand that because that.
I don't either.
Can you? I wouldn't gloss over that because this waiver is complicated. The motion judge finds there is waiver. The first appellate counsel doesn't bring the claim. You don't claim ineffective assistance on his part. Why then should we decide that waiver was inappropriate here?
Because I think that waiver in cases tends to be personal to the defendant. And I think if you look at the defendant's circumstances.
But like in Francis, we made that point that Francis, you couldn't blame the defendant the first time around because he wasn't there when counsel sort of basically skipped him. But here, I don't know, it just seems different.
How so?
Well, I mean, you've said, you're saying that, I mean, you're relying on the youth of the defendant. The defendant actually brings this up to appellate counsel. Then appellate counsel doesn't do anything with it, and you're saying that's okay, it wasn't effective, but now you're saying we should not find waiver. I just don't know what we do with all of that.
I'm not necessarily saying that it wasn't ineffective. I'm saying that it should not be considered as waived when you look at the actions or the what can be expected of the defendant. And I think that in addition to the nature of this structural error.
Wait. Wouldn't we then have to apply a standard to defense attorneys of their effectiveness would depend on how effective their clients were? I don't understand how that's going to work.
I'm not sure I understand.
I was just, never mind.
Yeah.
Are there any other questions?
No.
Okay, thank you very much.
Okay, thank you.
Attorney Martino.
Good morning, Your Honors. May it please the Court, Elizabeth Martino on behalf of the Commonwealth. I'd like, if I may, to quickly just go through the legal framework here because I think it's important. First, there's the gatekeeper petition issue, which if the Court agrees to look at the merits are that the one overarching legal issue, which is whether the motion judge properly denied the defendant's motion for new trial, whether he abused his discretion in denying the motion for new trial. Within that are
Counsel,
four...
I appreciate that because I'd like to ask you one question about the first issue. So there wasn't an evidentiary hearing in this case?
There was not.
Okay, so is this properly something we can decide? Because just take the issue about the critical stage. Let's assume for the sake of argument that I buy your sister's argument that it depends on whether it was a critical stage or a non-critical stage for purposes of whether or not he was sleeping and something ought to be done as a result of that. In the affidavit, her client says specifically and identifies specifically that these were critical stages that I said my lawyer was sleeping. None of the affidavits that were filed support that or corroborate that. But yet the motion judge doesn't say or give some indication that I just don't credit this because the affidavit from the client says these are critical moments and he was sleeping. I've got affidavits from the mother, from the other counsel that don't corroborate there, so therefore I do not find that he's met his burden. So is this a decision we should decide or is this something we should remand?
It's something you should decide. The four sort of issues, the first that is very important, and I'll go into that why because of the standards of review, but are the waiver issue. The next is whether the motion judge abused his discretion in articulating a legal standard for assessing whether there's structural error in the context of a sleeping attorney, and then whether he properly found, based on the submitted affidavits, whether the defendant made a sufficient showing that a structural error occurred here, and whether he properly found that it did not. And then finally, whether he properly analyzed and concluded that there was no substantial risk of a miscarriage of justice. The Commonwealth's contention, of course, is that all four of those things were done properly by the motion judge.
So break them down, though, because I have the same question that Justice George has. How do we do this without a remand when we can't tell when he's sleeping or not? So the waiver, the defendant actually brings it up to appellate counsel, right?
Yes.
So it's different from some other, it makes it a little harder to find waiver, right? He's brought it up and his lawyers, let him down.
Well, I think it's sort of muddying the waters a little bit between procedural waiver and the waiver of substantive rights. This is a case of procedural waiver where the court doesn't look into the specific defendant and what he knew or didn't know or his specific characteristics. The court looks at, was there a contemporaneous objection at the time of trial, was this raised in the direct appeal or in the first motion for new trial? If none of those are met, it's procedurally waived. And in I'll find the case, but this court has gone through.
The closest case is Francis.
Yes.
And there, we weren't, I'm not sure this meets the waiver standard in Francis. One, it's close. It wasn't, sat around for 30 years. And two, it may be a critical stage. Francis draws a distinction between certain things that you don't have to establish prejudice and some you do. This may fall into the first category, as Justice Gaziano said. If he's sleeping during, a momentous moment at trial, that's a real problem, right? But we don't know when he's asleep and when he's not.
Right. So turning to the first issue, which is waiver, it's important because it will establish the standard of review. So if the defendant waived, because you can waive a structural error, waive the issue, which he did here, because it was a procedural waiver, it was not raised at the time of trial or in the direct appeal or in the first motion for new trial. And the case I was looking for is Commonwealth versus Robinson, which is cited in both briefs, 480 Mass 146. But in the first footnote, this court said procedural waiver is different from the waiver of substantive rights. And procedural waiver is basically just a forfeiture of a standard of review.
Robinson's a public trial case, right?
Yes.
So again, though, we drew to some distinctions between in structural error. There's certain kinds of things that you just, like, you don't give the beyond a reasonable doubt instruction, you lose. You got to do it over again.
But you can still waive a structural.
We were pretty.
Well, in Francis, which was a Sixth Amendment case, the court said you can still waive it, and that in fact the defendant there did waive it. And although
we drew again a distinction in Francis, which I'm familiar with. We drew a distinction between the case, the lawyer, Hrones, is a good lawyer, and it's harder to evaluate. The issue was the client didn't get to choose his lawyer there.
Right.
We dealt with that differently than a case, for example, if you didn't give the beyond a reasonable doubt instruction, or if the juror was prejudiced. There was, so we've been careful to do just what Justice Gaziano talked about. There's certain kinds of structural error that just you don't have to show prejudice on, even if there's waiver, I think.
I believe that at least from Francis, which was a Sixth Amendment deprivation of the right to counsel, right, and the closed courtroom cases, all of which are structural error, they can still be waived procedurally. If they are waived, the court still looks at whether there was a substantial risk of a miscarriage of justice resulting from the error. So here, the defendant can still waive his right, which he did here procedurally because he didn't raise it. And as in Francis, where this court excused that it wasn't a contemporaneous trial objection because the defendant was completely absent during arraignment.
There's no way for him to have known.
Right.
Possible.
Well, again, yes. He didn't know, and he wasn't at arraignment, and so this court excused that there wasn't the contemporaneous objection at arraignment, but still, at the first possible moment that he knew, when he received the trial transcripts and he saw what happened at arraignment, he should have and could have brought the claim, but didn't, and he didn't from 1989 when he received the transcripts until 2015 when he brought it in his subsequent motion for new trial. And this court said in all those times, he could have brought it up and didn't, and it was procedurally waived, and he forfeited the standard of review for a structural error. The same is true here. The defendant knew all of the facts and circumstances. He knew that his attorney, he believed, had been sleeping during his trial. He brought it up to his lawyer. His lawyer did not choose to pursue it.
Say we buy your argument on waiver. We still don't know whether he was sleeping. Again, there are these monotonous parts of trial where if he's asleep, it's hard to, as Justice Gaziano pointed out, it's hard to make it that be prejudiced. But there are also these momentous moments at a trial where he can't be asleep.
Yes, Your
and we
Honor.
don't know if, like Rodriguez, right? He's the key witness. We don't know if he was sleeping during Rodriguez's testimony or the other person with a similar name, right? How do we do this without an evidentiary hearing?
So I first want to note, again, I think waiver is unassailable here. I think that this is procedurally waived. Going with that, the only standard to review here is under a substantial risk of a miscarriage of justice, and I think that matters because what you're looking at is prejudice. What stages, what evidence, Attorney Davis may have fell asleep through, and how it influenced the defendant's case. And as the judge in the motion for new trial said, this has already undergone plenary review under 33E, where ineffective assistance of counsel was alleged on different grounds.
But you give us too much credit. I mean, how could anybody on 33E review this issue when we didn't know the attorney was asleep?
Well, just to quickly note, reviewed the issue of the effectiveness of counsel and found that counsel vigorously, was vigorously defended his client.
Well, he was awake.
Well, he was awake. Yes, so let me move on. But I do think
How much of a percentage of the trial would someone have to be asleep before you would concede it was a critical error?
Right. So just, putting it, so I do want to say substantial risk of a miscarriage of justice, this court has looked at it and found that there was none. So under that standard, I think even, there was no substantial risk. Moving on to whether the motion judge here appropriately.
Don't broom that, because that's where the rubber hits the road here, right?
Well,
so how do we, I mean, look, when Mr. Davis was awake, he was a great lawyer. So how do we know that it wouldn't have made a difference? He doesn't stand up and object, or, we can't see that from a cold transcript.
Right, but let me go to, so the motion, so the court has to determine whether the motion judge abuses discretion in identifying a legal standard here and applying that legal standard. So the motion judge followed federal precedent, which was the U.S. Supreme Court Chronic case, as well as the circuit courts who have interpreted Chronic, to say that the standard should be that there's only a structural error where the attorney, and it's where the defendant can show that the attorney slept through a substantial portion of the trial. What Chronic says, and what the other circuit cases say that interpret Chronic, is that it's not only in the trial, but also other critical proceedings that are relevant to the trial. So perhaps, the other motions in limine or jury selection, things that may not be considered the trial as in taking of evidence, but other critical stages. So that is the critical stage that's referred to in Chronic and in the courts that interpret.
Oh, but that's just not right? I mean, the Chronic, we have to figure out, parts of a trial have got to be critical stages, right? Right? I mean,
The trial itself is critical, right? And so in its entirety, the trial, and then there are other critical stages that are not the trial that are also important.
So if the trial itself is critical, and
Yeah.
you're saying there are other stages that are critical, are you talking about pre-trials?
Yes,
Okay,
pretrial.
so
and
we have pre-trial critical
Yes,
stages, and
yes.
then all of the trial
And all
being
of the
a critical
trial. And
stage.
then what this court has to look at is whether the attorney was sleeping through a substantial portion of any of that.
But that's the question.
Yes.
And so this is, I guess I'm having the same issue that Justice Georges is having. Let's just say the first appellate attorney, he looks at the transcript. No, I'm not going with that one.
Yeah.
These are my best issues.
Yep.
It's unequivocal that there's procedural waiver.
Yes.
The case isn't, that doesn't end things.
No.
So how do we, I'm just asking the same question in a different way. Okay, so now how do we evaluate substantial risk with no factual findings, no record? How do we do that?
Well, first, you look at whether the defendant made a proper showing here, which the motion judge found that he didn't, because even taking all the affidavits is true, the motion judge found that the attorney was not sleeping through a substantial portion of the trial.
Well, if he's sleeping through, for example, Rodriguez is a key witness, right?
Yes.
He doesn't have to sleep through the whole trial. If he slept all through Rodriguez's testimony, would we be here? That would be a critical stage, right?
Right, and it's not established that he slept through the whole of his testimony, and Attorney Davis did a thorough cross-examination of the witness, so.
Did he object at any point when Rodriguez's testimony, or?
I'd have to look back at the record, but the motion judge found that he was effective all through that portion of the testimony. And in fact, what was raised, and this is all fleshed out in the briefs, but quickly, what was raised is that during, by the affidavits, during a 9-day trial, only the defendants identify like specific instances when Attorney Davis slept, and really it was only during either Jeremiah Rodriguez or Shawanda Rodriguez, and they couldn't remember. And then the co-defendant, Mattis, said he slept during the testimony of an EMT and Kevon Blake, which was not inculpatory against this defendant. Now, what's important is that there were 4 experienced attorneys here. There were 2 prosecutors, and there were 2 defense attorneys. Of those 4, one of the trial attorneys, Greg Henning, did not observe Attorney Davis sleeping. Lauer said he saw him with his eyes closed, but didn't know if he was sleeping, which, again, is not uncommon. Porges said she saw Attorney Davis sleeping once. And former ADA, now Judge Halal, said he saw a few occasions when he saw Attorney Davis dozing off, but he only specified one occasion where he said, I had to cough when I was showing him an exhibit. And I think what's very important is that of all these 4 experienced...
Showing a defense attorney an exhibit is a critical thing in a trial?
But he woke him up, so he wasn't sleeping during it. And what is important is that all 4 attorneys, which, I mean, again, we cannot fault, trials are long, and, a quick closing of the eyes is not a substantial portion. So he was woken up, and that's on the...
I still have this issue, though, because when you have, whether it's Attorney Lauer, Attorney Porges, or Attorney Halal, they've got their own issues to pay attention to. So the idea that they give an affidavit that doesn't necessarily align with what the defendant says, I noticed my attorney sleeping. Doesn't this warrant having a hearing here? Because just on the affidavits, I think you were starting to say it's a long trial so that every once in a while it's okay to shut your eyes, which I would vehemently disagree with you, okay? You're supposed to be paying attention. It's your clients that's on the line. Pay attention. So assume for the sake of argument that that's what they're doing for their clients and their sides. They're not looking at Attorney Davis during however long, multiple weeks that this thing's going on. So how do we do this without an evidentiary hearing?
Yes, Your Honor. Well, I think what's very important too is that we're looking at whether the motion judge abused his discretion in finding, that these affidavits did not raise a substantial issue. And I think in looking at these 4 experienced attorneys who, of course, had their own things going on, but they saw very little of any sleeping, if at all, and none of them brought it to the trial judge's attention. And this was an inference that the motion judge found, if they had seen something worrisome about Attorney Davis sleeping, there is an inference for sure that they would have brought it.
Are there cases, because to me, your better argument is that there are 2 other lawyers there, and the judge who's actually looking at the lawyers much more easily than the defense counsel never does anything. Are there cases that give us comfort based on those?
There are, Your Honor, and I would also note that appellate counsel reached out to all of the jurors who are looking at the parties, and none of them wrote back on this issue except for one who said he or she, didn't see Attorney Davis sleeping. And I would note, yes, and so just to look at the federal cases that discuss this issue, which are cited in the briefs at length, which are Reagan and Roy and all of the cases.
Does the fact that they're co-counsel, that there's a co-defendant and alert counsel for the co-defendants, do any of the cases point that out? Because it is odd that we're relying on someone else's lawyer.
Right. Well, I don't actually think that is dispositive at all. I think really what's more important is that the federal cases that flesh this out, the substantial portion that the counsel is sleeping through is much greater than here.
How do we know?
Much greater.
How do we
because
know
there's a showing from the defendant, right?
And an
that has to
evidentiary
be-
hearing.
Yeah.
Well, no, I think here there need not be, because the motion judge did not abuse his discretion in finding that there were 4 attorneys who gave affidavits and that he wouldn't
Each of
get any
them
more.
corroborated some part of something that the defense counsel is sleeping through. And the client is saying, yeah, he slept through jury selection and through, another witness who may or may not be the key witness.
Again, I would disagree with that characterization because of the 4, 2 said they did not see Attorney Davis sleeping at all. But be that as it may, I know this is something that the court will go back and look at, but I would note that I think that the motion judge's findings here, that the defendant did not make a correct showing, a sufficient showing based on the affidavits provided, and that because it was attorneys who provided the affidavits,
Can I ask,
he
but the
wouldn't get
standard,
more.
the standard for us, this is a documentary case, right? He wasn't the trial judge. So we're in the exact same position that he was in, right? Do we even owe him any deference on this? I'm just trying to, it's a pure document issue.
Well, the standard of review is whether he abused his discretion, right? And so in determining whether he, properly considered the affidavits and found that no evidentiary hearing was necessary, I think.
But that's the issue, though, isn't it? It's like, is there any reason not to have had an evidentiary hearing where you could have called witnesses and cross-examined them, including the judge?
Yes, and that is because the standard, the legal standard of whether there's a structural error was articulated correctly.
That's not the standard for an evidentiary hearing.
Well, but
That's just a really small standard to get over.
No, absolutely, sorry, but if I just can finish the point. So he correctly identified the legal standard, which is that the attorney has to be sleeping through a substantial portion of the trial. And then he determined that based on the affidavits, there was not a sufficient showing, even taking all the affidavits as true, that the attorney slept through a substantial portion.
So a substantial portion of the trial could translate to a small critical stage is not a substantial portion of the trial. It's just a sliver of the critical stage. So it's not substantial portion?
No, as the cases bear out, the substantial portion is that the lawyer is sleeping through most of the trial. And again, I'm not saying that should necessarily be the standard, but I don't think the court has to articulate the exact contours today. But it is, as you look through the cases, it's that they were sleeping, 10 minutes at a time. They were sleeping at various junctures throughout the trial for significant periods of the time, that they woke up and were like, oh, what's going on? So, I mean, the facts
So
bear
it's
out
really a
much greater.
quantitative standard is what you're articulating versus a qualitative
It can
standard.
be both, of course. I mean, the court can look at, well, was it, substantial, and was it during the key witness? That's not what happened here. But certainly if it was alleged that, the defense attorney had a, complete sort of sleeping episode during the critical, witness and didn't do a good cross-examination, yes, of course, just that sleeping episode could probably be enough. But again, the contours and the exact, standard don't have to be fleshed out in this case, because all the courts that have interpreted chronic, that are all laid out in the briefs, the substantial episodes are much, much, much greater than even taking the affidavits as true here allege. And so the motion judge did not abuse his discretion in finding that Attorney Davis did not sleep through a substantial portion of the trial, that the affidavits did not sufficiently support the claim, and that an evidentiary hearing was not required. And keeping in mind that waiver, I think, is unassailable here, and that even structural errors can be waived. So at the most, we're looking at a substantial risk of a miscarriage of justice.
Let me ask you this on the last point. Assuming procedural waiver, what we're really doing is we're looking at the affidavits, and if everything in the affidavits were true, is there not a substantial risk of miscarriage of justice? If that's the case, we've got corroboration, as has been said, to some extent of the defendant's affidavit, but the affidavit doesn't lay out how much of potentially Rodriguez's testimony he was asleep. Is that enough of a reason for a remand? Because if we take the affidavits, don't we have a question? How do we resolve that?
Well, I think the affidavit is just maybe Shawanda, maybe Jeremiah Rodriguez's testimony, I don't remember which. And so that is not a sufficient showing, and we can put the onus on the defendant, especially where the claim is raised years later, it's waived, and he's bringing forth, these affidavits, which even interlocking and taken as true, don't show that Attorney Davis slept through a substantial portion. And when you're looking at, again, the Commonwealth's contention is that there's no error here, right, because it was not a substantial portion. And then we look at substantial risk, and which is all the things, was Attorney Davis still able to do a cross-examination?
Substantial portion is the federal standard, right? Our standard is critical stage, right?
This court hasn't addressed it, but in Commonwealth versus Valentin, which is cited in the Commonwealth's brief, which was an issue of substitute counsel, this court said there had to be a total absence of an attorney during a critical stage. So momentary dozing, I don't think would rise to that level.
Sorry, Valentin is of our case?
Yes, it's out of
It's
this
our
court,
case?
yep. And I'm sorry, it's cited in the Commonwealth's brief. I don't have the citation right here, but
So
yeah.
you're saying that if we agree with you that if the critical stage is the whole trial, and we're looking at whether there was a substantial portion of that, then that we come out the way you're coming out. But if we think that it's more important to know whether the lawyer was sleeping during an important or critical stage of the trial, then we would have to remand. If we decided that it's not enough to know that the lawyer, whether or not the lawyer slept through a substantial portion of the trial, we need to know what part of the trial we're talking about.
I think that the most that the court can do in this case is remand for an evidentiary hearing. If the court finds against my positions in multiple stages, then of course, the court can remand and for an evidentiary hearing to try to suss out better exactly when Attorney Davis was sleeping and which portions. But again, under the standard of—
I understand yours. And then if we did remand it, and so then it would be up to the motion judge to see if he or she can figure out whether Attorney Davis was sleeping during a critical stage of the trial, right? And then what? What if the judge can't make heads or tails out of what they have in front of them, even after hearing, after an evidentiary hearing where they pretty much say what it is that they've said in their affidavits?
Yeah. Well, the answer there, Your Honor, would be that motion judge would have in their discretion to find that there was a structural error, because even after evidentiary hearing, they couldn't figure out exactly when, the defense counsel was sleeping, and there was a structural error. But here, the defendant waived it, and so he does not get automatic reversal, and so we still look at whether there was a substantial risk of a miscarriage of justice from the error. So it's almost like looking at an ineffective assistance of counsel claim. So the court would have to, the judge, motion judge, would have to assess, what was counsel's ultimate performance, his closing argument, all the things that the motion judge here did already, and that this court did already in its 33E plenary review. So even if a structural error occurred here because of the waiver, which is unassailable, the standard of review is a substantial risk of a miscarriage of justice. Another defendant may fare better if they raise the claim at the first possible moment.
Okay, thank you very much.
Thank you, Your Honors.